For Creamer Media's Polity, I'm Milan Solomon, and I'm joined today by Warburton Gunn Attorneys partner Adam Gunn, who will be shedding light on the state of South African mining law with a particular focus on sustainability and environmentalism. Welcome, Adam.
Thanks, Milan. Yeah, we had an interesting stage in South Africa's legislation and the mining industry. You know, we've seen what's happened following the events of Marikana, and the Farlam Commission is busy trying to come to some conclusions about what actually happened there. Although that deals with the social side of sustainability, the environmental side is becoming increasingly important. There are amendments on the table to a number of the laws which relate to the mining legislation framework. The principal act which governs the mines is the Minerals and Petroleum Resources Development Act, the MPRDA. That is currently under amendment in terms of the MPRDA Amendment Act, and there's a new MPRDA Amendment Bill. So there are a lot of changes in the pipeline to that legislation. But I think the most important points that mining companies strive for in terms of reaching sustainability is really how to address the issue of, you have an operation which is by its nature not sustainable, taking minerals out of the ground. But really what it is, I think, is trying to do the best that they have with limited resources, and therefore to be as efficient as possible, to use as few resources as possible in the process. So I think it's both about use of resources, and then it's about environmental impact, trying to minimize the environmental impact of mines, both on the biophysical environment, and to minimize the negative impacts on surrounding communities and maximize the benefits to those communities. So in that sense, we see the three P's of sustainability: people or your community, the social benefits, planet or environment, and prosperity or the economic benefits. And that's what mining companies should be looking at, and I think most of them do. Listed companies are forced to look at that because of the listing requirements. In South Africa, we have the King Code, which the companies have to report on these issues. And any shareholder or any person who reads annual reports will know that gone are the days of just looking at a set of financial statements. When you receive your annual report, there's more about sustainability of companies than there is on the actual financial achievements of the company.
And from the environmental side of things, you say from South African law, what do you say the major developments are?
Well, I think the major impact of mining has been, I think there's sort of micro and macro impacts. The micro impacts are almost the nuisance impacts and health impacts to communities around the mines, living in very close proximity: dust, noise, lighting, visual impact, those sorts of things. And if they are serious enough, there can be a health impact. The macro impact, I think a good example is acid mine drainage. We're seeing the effects now of 130 years or more than 130 years of gold mining in the Witwatersrand. And only now are we having to pay literally a financial cost to deal with those impacts. So it is well legislated. I think the issue is more in terms of the regulation. The legislation is there, but sometimes I think we fall down a little bit in terms of the regulation.
Thank you, Adam. That was Adam Gunn of Warburton Gunn Attorneys discussing the state of South Africa mining law.